Start in the 19th century. This is a partly trick question, but I'll ask the question here first. We're going to go worldwide. Think of the entire world. Think of what you know of history. What was the most famous wedding in the world in the 19th century? This is one you probably, somebody in the room should get.
Victoria and Albert?
Victoria and Albert. That's the obvious answer. So, there we go. So that's what one thinks of as a royal wedding in the 19th century. Now, I'm going to set your minds going. We're going to talk eventually at the very end about the most famous wedding in the United States in the 19th century. So you can think a little bit about your knowledge of what would be famous and what you might pull out as the most famous wedding in the 19th century. This is more a typical American wedding of about the same time, maybe a little earlier. This is a rural wedding in America. You're talking about a minister. I had a great-grandfather who was marrying Sam, and I've still got his Bible that he walked around with. And people would come to either his house or he would come to their house. It wouldn't typically take place in a church. You'd have the couple of the family around, a couple of witnesses. Okay, there'd be a marriage. Now, obviously it was different in an urban area, it'd be different in a Catholic area. We'll talk a little bit about those differences as we go. But this would not be an untypical rural wedding. So what are we going to talk about today? We're going to talk about the English law that dominated the United States for almost, I would say, certainly well into the 19th century and well into partly into the 20th century. And it's hard today when we talk about women's rights to recognize the tremendous barriers that were put up by English common law to women's rights in America. We're going to talk about the concepts of unity of person and coverture. I'll explain those in a minute. Some differences between the colonies, because there were very significant differences. And then what happened at the American Revolution, which is counterintuitive. At the American Revolution, the restrictions on women's rights got greater, not lesser. Now, the women's lost rights at the time of the American Revolution. We'll talk about why. We'll talk about some related topics. We'll talk about common law or self-marriage. Sometimes we think that the idea of a couple living together in sin is a modern concept. It's not a modern concept. It goes way back. There were times in our country when 40% of the marriages in particular areas would all have been common law. We'll talk about divorce, self-divorce, remarriage, bigamy, great topics. We'll also talk a little bit about women and citizenship. If you don't know where I'm going with that, you'll learn when I get there. And finally, we'll talk about the progress that's taken place in the latter part of the 19th century and the 20th century. And I think the last target date I have on here is 1992, when there were still things happening to open up opportunities for women who were married. Okay. As I talk, let's recognize that marriage has several different frames. There's a religious frame, so we talk about a marriage that takes place in a Catholic church, a synagogue, whatever institution you may have a thought about. We talk about a secular framework for marriage. We talk about marriage being registered with the government, and a government trying to control marriage, maybe taking a few fees along the way. And we talk about marriage as something that the community recognizes, that as a community, we support marriage. Okay. When we talk about marriage, it's important to remember that the United States, as we know, was founded by England. And we inherited English common law. Things were different in other places founded by the French or founded by other cultures. In English law, a marriage is a contractual event. Okay, so you think that it's an actual contract between two people. It requires mutual consent. Both parties are supposed to enter into it voluntarily and giving their consent. Thus, one of the concepts, as we've all lived through, in some degrees, is how old do you have to be able to give your consent? My wife and I got married when I was 20 and she was 19. She was old enough to give her consent. I wasn't. I had to have my parents' permission. In Massachusetts, it was 18 for women and 21 for men. The concept is lifelong. The concept is it's a faithful relationship. Although in history and in particular places we'll talk about in the country, faithfulness was always expected of the woman and sometimes expected of the man. It was monogamous, although we certainly know that there was a major to-do during the 19th century about a place around Salt Lake that did not quite believe in monogamy. And it was all in a Christian framework. There was an exception made for Jews, but with that exception, pretty much the whole English tradition was built around Christian concepts. So we're going to start off by talking about a famous 1700s marriage, 18th century, which is George Washington and Martha Custis. Martha Custis was the widow of Daniel Custis. He was 25 years old when he died, leaving her with 2 children. Anyone who has read the history of the biographies of either Martha or George would know they were both interesting people. Daniel Custis left Martha with 5 major plantations, 17,500 acres of land, okay, hundreds of servants, slaves, hundreds of slaves, and a total value in today's dollars of $65 million. Okay? The week after he died, she could go and sell the slaves. She could factor off the land. She lived a couple of years before she married George, and during that period she's reported to have been an excellent negotiator with the factors in London who dealt with tobacco. So she was a good business person, supposedly. Get used to how to do this. Okay. When she remarried George Washington 2 years later, they were both 27, it was his first marriage, she lost all legal rights. Literally, she could not rent out an acre of the land that she owned the day before. Literally, she could not sell a slave. Literally, she could not enter into a contract to deliver tobacco in London. Okay? Now, I'm not being figurative here. If you don't know this from your history, you need to understand that she did have no rights. Her children went under a trusteeship to Washington. Had one of the children wished to marry prior to their coming of age, so that they would have needed permission, he is the only person who could have given permission. She could not give permission. In other words, her permission didn't count. So let's go to the second First Lady, Abigail John Adams. Okay, another well-known pair. If you've ever read an Abigail Adams biography, you will know that Abigail Adams was one tough lady, and she believed in a lot of rights for women. She left an extensive will. It turned out, during her lifetime, she had supported a lot of the less well-off members of the family, with a particular focus on women. So her focus was the women who were, let us say, hadn't married well and needed help. And so her will listed a set of financial and personal items she wanted to give to these women. And then she left her 6 granddaughters the choice of what was left. But she died before John did. As a result, her will literally had no legal standing. It was never presented in a court. It was only found in her papers after their deaths. Okay? Because she was not a person. And thus we come to the concept of femme clothette. In the English law, and by the way, for those people who wish to correct my French, this is Norman French, which is what is used in English law, okay, in referring to the issues of the past. A femme sole is a term used for an unmarried woman or widow. Such a person had a full right, as did Martha Washington Custis, to enter into contracts in her own name, to own property, to manage the property, etc. A femme covert was a married woman. A married woman had no legal rights or obligations separate from her husband. Okay? She literally had the same legal standing as a child, a lunatic, or a slave. And does everybody understand the concept of why a slave couldn't enter into a contract? Because they had no free will. Their will was controlled by their master. So as a femme covert, her property, her income, and her person were totally controlled by her husband from the time of her marriage. He had an absolute right to what's called personalty, or personal property and income. So literally, if you were in a big city and you were talking about a married couple where the woman was, let's say, a maid or something, the husband had a full right to go to the employer and say, pay me, not her. Okay? He had a full right to sell her a piece of jewelry without asking her by your leave. In other words, all of her personal things he had full control. Her realty, meaning her real estate, she had some rights to it. We'll talk about those. They're called dower rights. And they're a little distinct from the idea of a dowry, although we'll talk about dowries as well. When a married woman's husband died, she had an absolute right to at least 1/3 of his real estate. Okay? Now, he could leave a will that would give her more than that, but he couldn't leave her less than that. And she had full rights to get back her own property, her own realty. Thus the idea of a dowry. She gets back her dowry in that case. With regard to realty, under English law, she had to waive these rights in order for land to be sold. So what would happen in Virginia would be if George Washington had wanted to sell 100 acres of Martha's land for perfectly good reasons. Two people would have been appointed by the local court. They would have taken Martha aside, where George wasn't present, and have said, do you agree with this? And she would have said yes. And they would have said, okay, she waives her rights. But that was a requirement. And literally, if you were a buyer of land and you didn't get that piece of paper with her signature on it, or the witnesses, okay, she could come back and take the land away from you, and there would be no claim against you. I mean, you would have no rights. She could take the land away. We'll talk a little bit later about it. I missed something back earlier. There. Trying to control this, I missed this. Let's go back and do unity of person now. Many of you may have heard of Blackstone. Blackstone was a lawyer in England in the middle of the 1700s who took this whole common law concept, which had been developed over the years, and turned it into a document that basically codified the common law. And so one of the concepts that had been in the law, but had not been stated quite as clearly, was the concept of unity of person. By marriage, the husband and wife are one person in the law. The very being or legal existence of the woman is suspended during marriage. She has no legal existence. It is incorporated and consolidated into that of her husband, under whose wing, protection, and cover she performs everything. And that is called coverture. So we're looking at the unity of person, and we're looking at the idea of coverture. Coverture is the cover. She's under his wing, if you want to say that. Okay? So any questions on the English law concept? I'd like to restrict it to that, but since we're staying with that, I can go broader. Okay, let me go ahead then. So The southern colonies followed English common law pretty much as you would have found it in England. And if you know the history of the colonies, you would have known why that would be true. They were pretty much just cut pieces out of England. But the New England colonies adapted it to conform to Puritanism. We'll talk about that. And Pennsylvania adapted it to conform to Quaker beliefs. Puritan living. The Puritans believed the husband was the religious head of the family. Okay? The woman was made for the man's comfort, but the man was not made for the woman's command. This is one of the Puritan thinkers in England. What that meant was, can you imagine a woman disagreeing with her husband under this concept? Because this was a religious, I mean, for those people who think that Puritanism was religious freedom, it was not religious freedom. Puritanism was freedom to practice Puritanism. Okay? That was all it was. So it turned out that in Connecticut and Massachusetts, the two primary Puritan colonies, there were no dower rights. Because if you think about it, how could there be dower rights? How could a woman disagree if her husband wanted to sell property? You follow the logic? I mean, makes perfect sense, because then she would be challenging the religion that had been founded on. And that would have been pretty severe. So they never bothered worrying about that. Now the Quakers, many of us know, I certainly had grown up knowing that Quakers, women were always encouraged to speak their minds freely. What I never quite understood was that it was still, however, the wife's duty to defer to her husband in all marital matters. So Pennsylvania also never had any dower rights, because it was inconceivable that a woman would ever disagree with her husband with regard to something that related to the family. Okay? So, turns out Virginia was better. Now, chancery courts. Chancery courts were a type of court that was developed in England. So you think about criminal courts and civil courts. Chancery courts were developed specifically to deal with estates, trusts, land disputes, things that really didn't quite fit either of the other categories. And one of the primary places they were used was when there was a disagreement between a wife and her husband or her husband's family. Puritans, Quakers didn't have them. They were in the South. Okay? But again, the Puritans, Quakers saw no reason to have a court that would oversee the authority of the man. Does any of this sound a little bit like what we sometimes pejoratively talk about when we talk about the Islamic religion? So, cometh the revolution, and the great democracy comes forth, other than the fact that we still have slaves and other things. So, the concept that developed at that time was that by consenting, citizens delegated authority to their elected representatives, as by consenting, wives gave authority to their husbands. So, in those places where there had been little glimmers of rights for women, they were closed down. In New Jersey, women had actually gotten to vote. That was closed down. And the reason was because there was this whole psychology among the founders that the idea of democracy was very consistent with the idea of the man in the household controlling everything, because they wanted the idea of representative government controlling everything. Okay, so marriage, a voluntary union based on mutual consent. Democracy, a voluntary union based on mutual consent. Over here you have polygamy, despotism, coercion. Over here you have monogamy, political liberty, and consent. Okay, you can just sort of read it, can't you? You can see the psychology of that. So how did people actually manage it? There are a lot of ways in which this doesn't sound like it's going to work. Well, first of all, marriage was socially and economically necessary, so it did occur. And most marriages worked well because the husbands carried out their roles. If you've ever read about the Washingtons, you'll know that Washington took his responsibilities for Martha's property and her children very seriously and worried a lot about it. Remember, one of his big issues with regard to freeing the slaves was the majority of the slaves he had control over were in fact the property of Martha and her children. And therefore he couldn't free them because he didn't have the freedom to free them, if you follow me. You follow that? Because he was holding them in trust for her and her children. Okay? So he could get rid of, and he did free his own slaves. Okay? But he did not free her slaves. And the community was very supportive. And you'll find if you look at the histories that the communities tended to be very supportive of marriage. And there were workarounds. In many cases, women would turn to a male relative, an uncle, a brother, whatever, who would do things that they couldn't do. So, you know, if John Adams was off in France and Abigail had to do some transaction that in theory she couldn't do, there were family members who could stand up and say, that's okay. Widows who had property from a first husband often did not remarry. I've got a family case where there's a woman who inherited 600 acres of wonderful land in Kentucky in about 1832. She had 5 boys under the age of 15. And so she didn't get married until the youngest boy got old enough that she could give them all their land. Okay, because she didn't want to lose control of the land. And then she got married. That was fine. And wealthy families would establish trusts so that the wife did not actually have control of her property. The property was in a trust. By the way, in many states that was not legal. All right, we're going to change topics slightly. We're going to go now to Rachel Donaldson and Andrew Jackson. For those of you who know the Jackson family history, Rachel was a young resident of Nashville. She married and not too well, and her husband abused her, and they agreed to a divorce. And lo and behold, she met Andrew Jackson, took a trip down to Natchez, Mississippi, and they got married. Well, I got a couple of problems now. First was that divorces in those days in the area they lived in could only be granted by the legislature, and it never went through. So she wasn't divorced. And secondly, she got married in Mississippi, where the only legal marriages were those performed in the Catholic Church, and she got married by a Protestant minister. So they weren't legally married. They got remarried 4 years later when, in fact, the divorce did come true. Benjamin Franklin, Deborah Reed. Deborah Reed was 15 when Benjamin Franklin proposed to her. Her family decided he was a ne'er-do-well. Besides, he was heading off to Europe. So they said no, you know. So he went off to Europe to England, where he was an assistant to the ambassador, whatever it was, the person from Pennsylvania. I guess he wouldn't call him ambassador. In any case, and when he came back, she was married. Husband abused her, and husband left. Nobody knows where he went. All those people who tried doing research, we never figured out where he went. But she couldn't get a divorce. Okay? She was married. So they lived together. They had 2 kids. They had a lifelong relationship. So they had a common law marriage. What is a common law marriage? I mean, just to be technical. It is an unlicensed agreement to be married that comes with cohabitation, people live together, and a public display that they are married. So to the community at large, they position themselves as if they are married. Okay? At one time in this country, that was universal. Every state recognized common law marriages. There's still 14 that recognize them. If you go back to medieval times, most marriages were common law. I mean, there were marriages of royalty and those kinds of, people who had property and they were trying to control property. But in terms of everyday people, most marriages were common law. In the 1560s, the Catholic Church required marriage to be performed by a priest with 2 witnesses. And in 1753, as English common law was codified, it clarified that marriage not only needed to be in front of a church member, but it had to be by a minister of the Church of England, unless it involved Jewish and Quaker. They recognized Jewish and Quaker were different. Well, this was what was active as a set of rules in Virginia at the time of the American Revolution. Well, I come out of Scotch-Irish background, and not many of us were members of the Church of England. And we were living on the frontier, and there weren't any Church of England ministers living on the frontier. Okay? So we never got legally married. If you go back into the 1740s, 50s, 60s, in that part of the country, 40 to 60% of the couples that were living together were not legally married under the laws. In addition to the availability of the minister, there was a cost. You had to show up at the courthouse with 2 people who would say that they would in fact back the marriage financially if it turned out the husband was a ne'er-do-well. I mean, if you think about the idea of what we're talking about, the husband's responsible for the marriage, right? Okay, now what if the husband turns out to be bigamous, turns out to disappear? Who takes care of the wife and kids? The answer is the people who signed with the state that they would put up 50 pounds, which was a lot of money in those days, to support the wife. It was common to have self-divorce and remarriage. The only person who could challenge a remarriage that was basically bigamous, the only person who could challenge that was the first wife. Let me read what's down here. I think it didn't come across. Wife, John, where is the rest of your wages? How am I going to pay the landlord and buy food for the children? Husband, shut up. What I do with my money is no business of yours. The memoirs of Mrs. Abigail Bailey. For those people who ever enjoy old books of this kind, I recommend this. Abigail Smith was a reasonably well-to-do family in New Hampshire and married Asa Bailey, who eventually became a general in the militia. Pretty reasonable guy. They had 15 children. After some 20 years, they ran into a little problem. It seemed he was developing an incestuous relationship with their oldest daughter, which didn't make her very happy. It got worse. In order to, in fact, keep the daughter under his control, he proposed moving the family from New Hampshire to Ohio and needed her to sign for land. That was New Hampshire, where women still had some rights. When she refused to do it, he took the daughter and another son off to New York, supposedly to be looking for a place, and then came back and got her and said, you need to go there with them. Took her out to New York and abandoned her while he went back to New Hampshire to try to sell the property on his own and get the hell out of town with the money. She had smallpox. It's a true story. And she makes her way back from New York to New Hampshire, goes and gets her brothers and uncles and the local sheriff and has him arrested. Okay. She then files for divorce. He prepares to take the children anyway. Under the law, he has a full right to do that. Okay? The local sheriff, however, convinced him it was probably a better idea if he just left town. So he left town with apparently the 2 older boys. But this is her diary. She kept a diary through this whole thing as she's worrying through, what's my responsibilities here? What do I need to do? What's going on here? And of course, she's thinking how horrible it would be if she actually divorced. Divorce, legal separation versus breaking the bonds of matrimony. In the South, you had very rare true divorces. You had separations that were fairly common. In New England, there were no separations. True divorce was easier. Eventually, over time, you had your first Reno. It was called Indiana. Legitimate reasons for divorce: improper marriage, bigamy. By the way, that was not automatic. Abandonment, abuse, infidelity, lack of support. I hate to, where's Hugh? I hate to reference this, but I will. In South Carolina, in the first part of the 1800s, infidelity was not a cause for divorce, because it was known that virtually all of the major plantation owners kept slave women, and therefore you couldn't say that that was a cause for divorce, because you knew everybody did it. That's true. The general idea in divorce for most of the time of the country, up until well into the latter part of the 1800s, was one party was guilty of a crime, like Asa Bailey in the story of his incestuous relationship, and the other was a victim. And so a divorce could be granted if you could prove the crime. Crime would have been bigamy. That would have been a crime. In that case, the party at fault following a divorce couldn't remarry. It was just the innocent party who had been wrong. In a divorce, generally speaking, in the colonies and the states through well into the 1800s, legitimate children went to the father, illegitimate to the mother. There was no idea of a child's best interest. Okay, that only emerged in the period after the Civil War. In other words, with that whole discussion about Asa Bailey taking his kids off, there was no part of that discussion that had to do with what was in the interest of the kids. It only had to do with his rights. What was quite common was self-divorce, followed by serial monogamy. If you read the histories of the founders of California, okay, the people who came out to the gold rush, in many cases, they left a family behind. And the family essentially then had to keep living. And they did not go back. Courts commonly recognized the marriage as legitimate. The Supreme Court of the United States ruled that a so-called bigamous relationship was in fact legal if it was recognized by the community and there was no challenge from the prior wife. And the general psychology was that bigamy was better than a legal divorce. Okay, so sort of turns upside down some of our thinking today. Voting. Because of the unity of person idea, one of the strongest arguments against women getting to vote was that it would simply give a man two votes, a married man two votes, because he could obviously command his wife to vote whatever way he wanted her to. Okay, so that was one of the strongest arguments against women's suffrage. So we'll talk about immigrants for a couple of minutes. Just a typical picture. I've got plenty on the Polish side too. Norwegian marriage. This is an interesting couple we'll talk about for a minute. Helen Emery's father was the rector of Grace Episcopal Church in San Francisco. They had missionary work in Japan and had converted a number of people, including Gujiro Aoki, who came from a well-to-do samurai family in Japan. And he came over to the United States in order to train more properly for an Episcopal position. Well, he met Gladys and they wanted to get married. This was 1909. This hit the papers. It was just, you could not believe anything more atrocious was going to happen. They got on a train and they went north and they stopped every place they could going north trying to get married. And meanwhile, the newspapers were reporting this as they went. They got turned down in Eureka. They got turned down in Portland. Finally, they got to Seattle and they were able to get married. And then after a few years, came back to California. Marriage, particularly to someone who was not Caucasian, was not necessarily encouraged for women. citizenship. An immigrant woman's citizenship followed that of her husband. So for those of you who had people who came over in the 1880s or 1890s, you would know that the man came over, let's say, with a wife and 2 children, okay? So they were all immigrants. 7 years later, he gets his citizenship. The day he gets his citizenship, so does his wife, so do the children. In other words, it was one package. They did not separately get citizenship. The concept then developed that if there was a free white woman who was foreign, who married an American citizen, she should be a citizen, right? So she became a citizen. At the same time, the concept emerged, technically, that the child of an American male born abroad would be a citizen. Okay? No, not female. Then, as we got more immigrants, there emerged a feeling in the law, in court cases, that an American-born woman who married a foreign man was no longer a citizen. And different states had different courts. So when it finally got to 1907, it was codified. You're an American citizen woman, you marry a foreigner, you lose your citizenship. So Gladys, remember Gladys, 1909? Gladys shows up in the 1910 census, 1920 census, married, and not a citizen, because she's married an alien. Now, in 1922, that was reversed, okay? Except if you were an American woman who had married an Asian foreign national. And the reason for that was because Asian foreign nationals could never become citizens, okay? They were prohibited from citizenship. Actually, in the 1940s, it finally got fixed. Okay, we're going to hit some odds and ends as we're going around. Slaves couldn't marry. We talked about that. They had no free will. So if you think about the concept of the contract of marriage, they couldn't enter into that contract because they could not give their consent. There was a ceremony that was often performed called jumping the broom, where a slave male and a slave female would in fact stand among their friends, other people they knew, and they would go through the ceremony which would recognize that in fact they were cohabiting under some sort of a socially acceptable system. It was illegal in most southern states for a minister to be at that event. In other words, you couldn't even begin the process of saying that this might be legal. One of the interesting problems that occurred after the Civil War was a lot of people felt that the freed slaves now should be granted marriage. But one of the problems you had is because families had been broken up and slaves had been sold, which of the partners over your lifetime were you supposed to now be married to? And quite frequently, it wasn't the last one. Then there are the Mormons. This is a picture of Joseph Smith's extended family at one point. The Mormons believed in polygamy. Finally, in about 1897, the U.S. Supreme Court ruled that a law that had been passed was legal. The law had said that if you believed in polygamy, then that was not a religion. Okay? And it was, if you believed in polygamy, whatever it was you were wasn't a religion. And therefore, that all property of the Latter-day Saints could be confiscated. And you know what? Within a year, they no longer believe in polygamy. True story. We've talked a lot about the law in English America. There was obviously French America, Spanish America. While generally speaking, the law still said that the man had the senior position in the relationship of marriage, the land ownership issues were much more open. The women could own land, they could sell land, they could have property. In the history of America, one of the Early settlers, many of the early settlers ended up marrying Indians. Obviously, all those marriages were men marrying Indian women. Pass on that. By the way, does everybody know that slavery goes with the mother? Okay, so that the child of a slave mother is a slave. Okay, Indians could never be made slaves by law. So if the mother was an Indian, regardless who the father was, the child was not a slave. Over time, one of the problems that occurred in this country was many of the Indian tribes had marital situations or situations of cohabitation that were in conflict with English law. They're perfectly consistent with other cultures, but they were in conflict. And so a lot of what we did in the early years to try to settle the Indians, to try to civilize them, was to force them to come to our system of marriage. You tell me how to pronounce that word, Jerry, or do I have to try? Ketubah?
I can try.
Ketubah. Okay. One of the differences in the Jewish faith has been that there's the existence of a Jewish document called Ketubah, which is a marriage contract, which has been recognized in the English courts, where a Jewish couple can enter into what I would loosely call a prenuptial agreement, where the woman's property is delineated and her rights are delineated. And that was recognized. So what happened over time? As the 19th century went on, the state laws became more standardized. The legal rights of wealthy women were enhanced. Okay? And chancery courts began to give, and when they existed, gave wives more rights. Beginning in 1848, laws were passed that did away with the technical idea of coverture and gave married women the same rights as femmes sold. However, as late as the 1950s, there are still court cases being decided that were referencing common law cases that came before these law changes. So what would happen would be that a woman who felt she had rights, which in fact she did have rights, would lose in court because the court would refer to common law cases from the past. A couple of tidbits from the 20th century. The Economy Act of 1932, one of the first of Roosevelt's acts, prohibited two people from the same household both holding federal jobs. Okay, and because of the way in which history had worked, the people who lost their jobs were predominantly married women. The GI Bill, one of the great documents of our lifetimes, inherently favored men because 98% of the people who it applied to were men. Okay, it didn't literally favor men. Under the law, if you think about unity of person, a woman could often get away with a crime by saying, "My husband made me do it." Because, after all, she had no separate legal person. Okay? If he told her to go out and steal that car, well, she's supposed to do it, right? Okay, she's not guilty of doing anything wrong. The last case that was decided that way was 1972. I don't know. The 1930s, women won more control of their financial affairs. No-fault divorce, which we sort of think of as almost standard now. First law was 1969. Okay. And spousal rape was not allowed in the last state until 1993. So, while today there are still over 1,000 references in the Federal Register to marriage, married people, there are very few distinctions between the rights and responsibilities of men and women, although many distinctions remain between men and women without regard to marriage. One of the more interesting ones to me is that women do not have to register for the Selective Service. Okay? Which, if you think about it, and you say, why would that be true? And the answer is because they can't serve in combat. To love, cherish, and obey. My wife said obey. My grandmother didn't. Everybody sort of followed the Kate Middleton fuss recently, where she didn't say obey. You know that Queen Elizabeth did. Okay, just as a side. 40% of all weddings today are estimated to still include the word obey. All right, almost done. What was the most famous American wedding of the 19th century? All right, there comes the historian. Bob Kirk.
I'd have to argue that it was P.T. Barnum's publicizing Tom Thumb's wedding.
Easily. Easily.
What I read, George?
You can give the next lecture. Absolutely. If you think about celebrity weddings, this one for $1,500, you were allowed to attend their reception. This is in 1863.
Oh my gosh.
So Mr. Barnum knew how to. They didn't have any children. He was infertile. She, in fact, did have children by other husbands. She outlived him significantly. All right, that's marriage in America.
Wow.
Take questions.
We're going to be running 2 mics here now, too.
Thank you, George, for a unique presentation. Regarding divorce, it seems to me, my recollection, I wonder why. People had to go to Reno to get divorced for years and years. What was so unique about having to go to Reno?
Well, let me talk about Indiana, because that occurred much earlier. Essentially, divorce was subject. Did everybody hear his question?
No.
Okay, Jerry's question, as usual in partial statement, was that didn't people have to go to Reno for years? The history of divorce, of course, always contains several elements. One of the elements is the residency issue, okay? Another element is what is the proof that has to be provided, okay? There are other elements in that. Indiana early on developed what they eventually reversed themselves on, eventually became Reno's game. But they developed short residencies, only one party had to be present, and virtually any claim was accepted in court. Okay, so in effect it was virtually a one-sided no fault. So that was the answer. Because a lot of the other states had much more strict rules. And by the way, one of the things you will note from that, and I should have said this earlier, marriages and divorces were generally recognized across the colonies and states. So that, you know, if you went to Indiana and you got your divorce, you could come back to Massachusetts and the divorce was legal. Okay, so we from an early period had that.
An interesting point in regard to your alien and citizen marriage. My mother could trace her family back to Jamestown, Virginia. My father was a German immigrant. He had not yet received his citizenship at the beginning of the First World War. So my mother, who could trace her family way, way back, had to register as an enemy alien during the First World War.
Others?
Oh, can you hear me?
Yeah.
My grandfather was the legal counsel for the five. Okay.
Right there.
Good. My grandfather was the counsel for the 5 civilized tribes in Indian Territory, and they had sovereign rights. And there are a number of questions like this one that you're dealing with. In the Cherokee tribe, the right of ownership stayed with the land, stayed with the Cherokee tribal group, the supremacy. People, when the children were born, were all given 50 acres of land. When they died, the land went back to the Confederation. Do you know anything about their marriage laws? Were they different?
No, I don't. I will make a comment about the Cherokees because there's an interesting historical nuance there as well. In the 1890s, there was a census taken of people to determine who were of Cherokee blood. And it was very well documented because there were some rights that were associated with Cherokee land. And today, if your name is on that list, you can be a member of the tribe. Not quite. There were two lists. One list was of people who were white. So they were combinations of Cherokees and whites. The other list was people who had parentage that were black. Today, the second list doesn't count. It's only the first list.
I'd like to go back to Martha Custis. You did mention later in your lecture, George, that some widows who had property elected not to get married so that they could give that property to their children. Now, Martha obviously made a very good choice in a husband, but what was the quid pro quo for her to be a married woman as opposed to a wealthy widow?
You're asking me?
Yeah.
As I said, in my own genealogy, I've got a very vivid case of a woman who elected not to get remarried and ended up controlling property. I have another case of a woman whose husband was killed in the early French and Indian Wars around 1755, and she didn't get remarried, and she was one heck of a lady. She owned a lot of good property around Colonial, Virginia, and she counted coup. I mean, when the local powers to be wanted to do something, they came and asked Martha, and she got her permission to do it. You had a lot of power if you weren't married.
My question has to do with frequency. In my business career, I got to know quite well a man named Tommy Manville. Any comment about Tommy Manville and his frequent marriages?
No. But generally speaking, the concept of frequent marriages, you know, we're a society that has recognized serial monogamy, okay, and now we connect it with divorces, okay, so we tend to be a lot more accepting of the idea of relationships as long as while they're going on, they're monogamous, and that has been true for a long time. Yvonne.
You mentioned that that the Asians weren't allowed to become citizens.
Right.
Why were they the only group, or why? Were they some kind of a threat? Were they not understood?
There may be a good California historian here who can answer that question better than I can, but I believe a lot of it goes back to the Chinese immigrants in California and the feeling that they were not us, okay? Even, although, you know, I like to think of myself as young, but I'm old enough to have moved into a community in New Jersey, okay, and when I was in high school, and the realtor told my parents about the Italian family who lived 2 blocks away to make sure that we wouldn't be mad about that neighborhood we moved into. Yes, sir.
Were any, to your knowledge, were same-sex marriages in the 19th century, common law or otherwise?
No, and I thought a lot about that because I'm not aware of it. Because if you think about what we've talked about, what you've got is a role for the husband and a role for the wife. So even if you took away any sense of propriety, okay, same-sex marriage is fine. Okay, let me ask the question. Do you then end up with 2 women, neither of whom have any legal rights?
No,
or 2 men?
2 husbands.
Well, no. You can't have 2 husbands. So what is the legal situation, okay, of such a person in such a circumstance? Because these were predominantly commercial contracts. I mean, if you think about them, that's what they were. And so the commercial contract said one person was giving up, one person was gaining, okay? And that's really hard to try to figure out when you try to figure out same sex. And there may have been an answer, but to my knowledge, there was virtually nothing in that vein that was public.
Where's your question?
You mentioned that your parents were married 70 years. I wondered, what is the Guinness Book of Records for the longest marriage known that they hold?
Don't know. Anybody who has a handy iPod should check it. Don't know. Our family, I can get it to 75 years within the family easily.
We got any other questions? Great, we'll see you here next week. Also, in the front, somebody left a little pie plate from our great party. It's up there if you want it. We want to thank you for coming and thank George for a wonderful presentation, and we'll see you next Sunday. Thank you.